Okay, great. All right, let me see. Let me just check. I don't know if I can switch you back. Let me
Don't
see,
miss out.
Claire.
I think you're gonna have to do it.
I'm just gonna take it. Yeah, exactly. Okay. Um, all right, we have 1 more minute. And then I will start. Please, if you're just joining us, welcome. And please do put your name and affiliation in the chat box so we can know who you are. And because I'm going to be doing introductions and admitting people at the same time, there might be a little staccato component to my introductions, but welcome everybody. All right, so let's get started to honor everybody who is here and certainly to honor our guests who are speaking with us today. We're thrilled to have them. This webinar is being sponsored by the Maryland Campaign for Environmental Human Rights. It's a new organization that was founded several months ago, but it is an organization that was founded after 3 or 4 years of work by many people promoting an environmental human rights amendment in the state constitution. We believe that for all of us to protect the environment as we know that it needs to be protected, and to make sure that environmental justice is pursued throughout the state. Just 3 people are in the waiting room. Hang on, there we go. That we need not just good laws and good regulations, although we do need them too, obviously, that's what we're talking about today, but we need the legal underpinning, the durable legal underpinning that would provide those rights. And that can only happen if, in fact, we have a constitutional amendment that preserves and asserts those rights. And that's what we were founded to do. But what we discovered as we were pursuing, let me just see who's in our waiting room. What we found out that as we were pursuing the amendment is that we could not achieve all those rights with an amendment alone. What we needed were laws and regulations that would interpret and bring to life and implement the rights that we were fighting for. And along the way, I bumped into Evan Isaacson, who told the organization about the Maryland Environmental Policy Act, which is an act, as you'll learn about in a minute, that has been on the books for 47 years in Maryland, and it has tremendous potential, even as it sits, but it has greater potential if we figure out how to use it properly. And it would help us achieve these rights that we're struggling to attain in creative ways. And so one of the things that we did also was look and find who would be the best experts to talk to us about the Maryland Environmental Policy Act. And along with Evan, we discovered Russ Stevenson. And as you saw, I hope in the flyer that we sent around, Russ Stevenson not only wrote a paper on reinvigorating the Maryland Environmental Policy Act. I think it was in 2014 that he wrote it. And I know we sent the paper to some of you, and others of you who registered after we sent out the paper will send out the paper again. But Russ also was the founder and is now the chairman of the Chesapeake Legal Alliance, an extraordinary Maryland legal organization that helps environmental organizations such as us, others in need of legal advice for free. To get the work done that we need to get done. So if you're looking for great environmental organizations to support as the end of the year comes and you're looking to make donations, consider Chesapeake Legal Alliance. He is also a member of the faculty of Georgetown Law School. He's been in private practice. He's been a regulator, an in-house counsel. He's a fabulous resource to talk with us about the potential and the practical aspects of the Maryland Environmental Policy Act. And Evan joined Chesapeake Legal Alliance just this past year as Director of Policy and Research. Prior to that, he worked in the Maryland General Assembly as a bill writer. He knows Annapolis in and out. He knows regulations. So he knows also the nuts and bolts of how to get things done. So we are thrilled to have, let me just get all of my admittance in. We're thrilled to have both of them present to us. And with that, I will stop talking. And Russ, I send this over to you.
Thank you, Nina. I am delighted to be here. As Nina said, I discovered the Maryland Environmental Policy Act quite by accident when a friend of mine in the environmental movement mentioned its existence. I had never heard of it. Uh, and so I began to look into it and ended up writing the article which Nina mentioned in an effort to try and make the good provisions of the Act more widely known and perhaps more widely used. And I can't tell you how delighted I am that Nina found me and this article, and we are now able to give it some wider publicity. So let me begin by talking about what we're going to cover today. First of all, I'm going to spend some time talking about the background of the Act. And then I'm going to talk about some of its major provisions. There's a wonderful broad statement of policy that almost sounds alien today in today's political environment. It includes a charge to Maryland agencies to behave in a certain way consistent with the policies. And it requires the preparation of environmental effects reports for major state actions, when we'll talk about what that's all about. And then I'm going to talk about what happened to MEPA in the interim, and then I'm going to turn it over to Evan to talk about how we might go about resurrecting the Act and turning it into, helping it live out its promise. So let me take you back in time, a little trip into history. In January the 1st, 1970, President Nixon signed the National Environmental Policy Act. President Nixon signed the National Environmental Policy Act, which was passed overwhelmingly and bipartisanly by Congress in 1969. In April 22nd, there was the first Earth Day. All of this in response to a reaction to the ugliness of what had happened to our environment. Some of you may remember the Cuyahoga River in Cleveland catching fire and creating a national scandal, which led to an environmental movement which really swept the country and resulted in NEPA, Earth Day, the Clean Air Act, the Clean Water Act, and a variety of other environmental legislation. MEPA, and I'm going to have to be careful, MEPA and NEPA sound alike, but MEPA, the Maryland Environmental Policy Act, was passed by the General Assembly in May of 1973. And Maryland was the first state to adopt a state equivalent of the National Environmental Policy Act. It was followed by 20 or 30 other states, which adopted laws that were more or less based on the National Environmental Policy Act. Now there are about 31 states that have similar statutes. Much of the language of MEPA was taken from the National Environmental Policy Act. Much of it lifted directly out of that statute. And that includes this wonderfully broad statement of policies. And I'm going to read them because they sound so good today, particularly in light of where we are politically. The protection, preservation, and enhancement of the state's diverse environment is necessary for the maintenance of the public health and welfare and the continued viability of the economy of the state, and is a matter of the highest public priority. All state agencies must conduct their affairs with an awareness that they are stewards of the air, land, water, and living resources, and that they have an obligation to protect the environment for the use and enjoyment of this and all future generations. Each person has a fundamental and inalienable right to a healthful environment and each person has a responsibility to contribute to the protection, preservation, and enhancement of the environment. Wouldn't it be wonderful if we could put that language in the Constitution? The policies, rules, regulations, and public laws of the state shall be interpreted and administered in accordance with the policies set forth in this subtitle. That is about as broad a statement of pro-environmental policies as I think we can find anywhere. Unfortunately, it has not accomplished very much. So let me talk about the various provisions of the Act. It's not a very long statute. It contains a variety of procedural provisions. The first of which is that it requires the preparation of environmental effects reports, which are the rough equivalent of an environmental impact statement, for those of you who are familiar with that branch of NEPA. And such a report has to be prepared for each, quote, proposed state action significantly affecting the quality of the environment. Sounds great, doesn't it? Well, I'll tell you what happened to that. It requires, the second procedural provision is it requires that state agencies identify, develop, and adopt methods and procedures to assure that, and this is a summary, environmental values are given appropriate consideration, that the agencies develop appropriate alternatives to present policies, programs, and procedures that involve significant adverse environmental effects, and that planning and decision-making are transparent and coordinated with the public. There are two substantive provisions, and I have a question mark here after substantive provisions because they sound substantive in practice. They sound like they require certain things to be done, but it's not clear that they have been interpreted that way. The first is that the policies, rules, regulations, and public laws of the state shall be interpreted and administered in accordance with the policies set forth in this subtitle. That sounds to me like a mandate to the agencies of the state to behave in a way that treats the environment with the kind of respect laid forth in the policies. And then it also says each person has a fundamental and inalienable right to a healthful environment, and each person has a responsibility to contribute to the protection, preservation, and enhancement of the environment. What we are lacking is a way for us to enforce that right as a matter of law. Well, let me talk about what happened to MEPA. It sounds great. What I have read you, I think, sounds terrific. In practice, it hasn't turned out quite that way. First of all, it's important to understand that MEPA was based on NEPA. And what happened to NEPA, even though it has language similar to the language I've just read you, it essentially turned into a requirement that agencies, federal agencies, prepare environmental assessments, and then if the environmental assessment showed that it was necessary, an environmental impact for, quote, major federal actions significantly affecting the quality of the human environment. Now, as many of you know, that remains a very powerful tool for environmentalists. The necessity of preparing environmental impact statements has enabled environmentalist advocates to block a lot of very bad projects. And I think it has also resulted in the improvement from an environmental standpoint of projects that did go forward. But that's about all that NEPA has done. Now that's all the focus of NEPA. The other language in NEPA, the broader language, has largely gone by the board. And what happened in the General Assembly is sad, even though this was in 1973 when environmental advocacy was riding high and very popular with the public. The original draft followed the NEPA model and the definition of what required environmental impact or environmental environmental impact reports. But the General Assembly, under lobbying from industry, gutted this, and it defined proposed state action to be requests for legislative appropriations or other legislative actions that will alter the quality of the air, land, or water resources. In other words, these environmental effects reports apply only to actions that require an agency to go to the legislature to ask it to do something. And as you can imagine, that doesn't happen very often. And so there have been precious few of these environmental effects reports prepared. In the agencies, notwithstanding the mandate that agencies adopt methods, procedures, and so forth to make sure they behaved in a manner consistent with environmental protection, only 3 agencies actually adopted methods and procedures. Those are the Departments of Planning, Transportation, and believe it or not, Labor Licensing and Regulation. The Department of Agriculture doesn't have any such regulations. And the Department of the Environment, which was not created until 1987, still doesn't have any MEPA rules. By the time the DOE was created, my guess is that everybody had pretty much forgotten that MEPA existed. Well, so what that means is that MEPA has effectively become a dead letter. There are only 3 judicial decisions interpreting MEPA in the courts. 2 basically applied to the environmental effects requirement, report requirement, and both of them held that in the particular case in that lawsuit, the EER requirement didn't apply to an agency action. And one held, unfortunately, that MEPA did not create a right enforceable in a private action for nuisance. So MEPA has basically, since the early 80s, largely been forgotten. It's neglected, forgotten, and a dead letter. And the reason I wrote this article was to see if we couldn't revivify it, bring it back to life, and give it some teeth. And with that, I'm going to turn it over to Evan to talk about how we might do that. Evan, over to you.
Thanks, Russ. Right, so I'm going to cover a few things on my slides. For the most part, I'm going to discuss what Russ just mentioned, trying to reinvigorate the statute. I'm going to describe what I see as sort of 5 different categories of potential improvements. And then I'm going to briefly discuss a few of the limitations, not to dwell on the negative, but merely to tamp down expectations, because this is not, as I will discuss, meant to be any sort of a replacement for a constitutional amendment. It's not even close. It's more an incremental improvement, I suppose. And then finally, I'll discuss very briefly just how this fits a little bit with the campaign that Nina is leading. So these are the 5 on the slide, 5 different categories as I see it. I'm sure a creative person could come up with some additional sorts of improvements, but having given some thought to MEPA and to where we are today, not where we were 47 years ago, but where we are today and what the campaign is trying to accomplish. These are a few of the things that I thought seemed important. So, we're talking about the environmental effects reports, as Russ mentioned, which is similar to the federal EIS. We're talking about more transparency, more meaningful, that's the keyword, public participation, proactive consultation from agencies to specific affected communities. And then I'll just very, very briefly discuss some judicial consideration of MEPA's lofty goals, the language that Russ read that seems so exciting to folks like us. I know there's not probably a ton of lawyers on here today, but I'll just briefly go into that. Next slide, please. Right, so the first potential benefit is implementing this procedural requirement to write what are called environmental effects reports, and potentially to go beyond the scope of the statute and develop certain findings. So even if you're not, even if the agency is not required writing a full environmental effects report, it's possible that you could implement MEPA by creating a process whereby the agencies develop certain written findings that describe the potential impact on the environment of various agency actions. So that's a little bit outside the scope of the EER, but it's something that we could, it's an incremental improvement we could seek. Secondly, I think the hard part for those of you here who are familiar with the National Environmental Policy Act, or NEPA, is the EIS is a pretty powerful tool, right? It requires the agencies to take a hard look. That's the term that many lawyers and folks familiar with NEPA are familiar with. They're required to take a hard look at the potential impact of their actions. And that, in theory, forces agencies to think through alternatives and come up with select the option that provides the greatest benefit at the least, potential impact on the environment. But I think it's important to understand here that MEPA in Maryland is not NEPA. As Russ mentioned, the environmental effects report is not an EIS. And the primary reason we say this isn't because it doesn't necessarily have the same sort of effect. If you're forcing an agency to sit down and describe the potential impact of their action, that would have a similar impact as an EIS, even if it isn't necessarily as long or detailed. The reason why an EER is not nearly as powerful is, as Russ mentioned, that it is hardly ever invoked. The triggering mechanism is, as Russ mentioned, requests for legislative appropriations or other legislative actions that will alter the quality of the air, land, or water. So I can tell you, I've never seen an EER in my dozen or so years working on environmental law and policy in Maryland. I've never seen an EER. I've never heard somebody talk about an EER. And partly it's because, it's become a dead letter, this law, but it's also, there are regulations on the books, but it's just unclear when an EER would ever be required, because that language, request for legislative appropriations or other legislative actions, is so ambiguous. So one incremental improvement is going to need to be describing the triggering mechanism for production of an EER in a way that makes sense to agencies today. So that would be one improvement. And what would that get us? Well, it would get us some additional transparency into the agency decision-making processes, and it would get us forcing the agency, whenever they undertake some specific action, it would require them to sit down and think through the potential effects. And that has some promise. Overall, though, I don't see the EER being any sort of particularly transformative solution. So in the next few slides, I'm going to turn to what are, in my opinion, some of the more promising potential reforms that a reinvigorated MEPA could have. Next slide, please. Right, so transparency. For those of you who are regular visitors to Maryland agency websites, I'm not sure how many that would be on here today, but for those of you, I'm guessing your overall impression is that it's an experience that leaves something to be desired. The agency I'm most familiar with is the Department of the Environment, MDE. The MDE website is hard to navigate, to say the least, and it contains a mix of some useful and modern data portals, and then some extremely basic data accessibility options. the average Marylander is not likely going to find what they're looking for and be able to access it. And, you know, in the limited amount of time that the average person has to be perusing the MDE website, chances are they're probably going to not find what they're looking for, and they'll either find that the Public Information Act gives them the right to request that information, or they'll go about their day. And that's the status quo, and that's frankly unacceptable in a world that MIPA envisions. So let's envision what it might be like if transparency was at the very core of the agency's mission. To my mind, concretely, that would be a unified data and transparency webpage accessible at the top of the agency home screen. It's not a portal that's maybe useful, but then buried and accessible only if you click on the next 5 links in the correct sequence to unlock that information. I think the fact is, as you might imagine, that agencies do indeed operate in the 21st century. Your average agency staffer has a laptop and internet. Most of the information that they receive or produce is, in fact, electronic, even if that's not the way it appears based on, you know, how we interface with the agency. Oftentimes, we're buried with paper files. That's not acceptable. It's not the way the agencies operate, and they shouldn't be burying the public in paperwork when you're requesting information. So given that fact, it's reasonable to envision that most of an agency's information should be, because it is public and most of it is not confidential, it should be posted electronically and easy for you and I to obtain online. So MIPA, if MIPA was implemented in the way that it was written, granted 47 years ago, it would require these agencies to view the public as partners in their mission. It says, I'm quoting here, it owes the public the fullest practicable provision of timely public information and understanding. So they would be required to, essentially, to view us as allies. And I think part of the problem is 40 some years later, the way that many agencies exist is they feel under attack from all sides. You know, we're just stating the fact here. They're under attack from the entities they regulate. They're under attack from elected officials, especially those of a certain ideology. And if we're being honest, they're under attack by folks like us who are advocating for the public interest. It's not that anybody is out to get the agency, but it can kind of feel that way if you're an agency staffer. We all have a role to play in changing that. I think that in itself is something that can lead to some incremental reforms and change in Maryland, not just reinvigorating MIPA, but reinvigorating the way we interact with the agencies. I think that's also an important aspect of creating a more transparent agency in Maryland. All right, next slide, please. All right, so public participation. For the advocates and lawyers here, the term public participation, I think oftentimes connotes the statutorily mandated processes that accompany certain agency actions like the issuance of a permit or promulgation of regulations. Agencies are accustomed to implementing these public participation laws, and they sort of view it as a check the box exercise to make sure that, you know, the basic legal requirements are met. But what MIPA can possibly help us with is going beyond sort of the bare minimum that the law requires and aim for meaningful participation by the public. So numerous provisions in MIPA establish a right or a duty to create a greater degree of public participation. And what might this look like? I've laid out sort of 3 things. First, the public can't participate if it doesn't receive the invitation to do so. Agencies cannot rely on outdated methods to get the word out. Agency staff should be thinking about public participation, in my opinion, as if they are a member of the public, which, by the way, they are. Agency staff like you and I, we all live in the 21st century and rely upon 21st century forms of communication. It should not be that difficult to modernize the way that agencies solicit feedback from the public. Secondly, meaningful participation means inviting the public early enough in the process to make a difference. As it is now, too often the agency spends significant time thinking about what they want to do, and then only after they make a final decision do they then extend this sort of perfunctory public participation opportunity where the public can then submit comments or attend a hearing, and that's the end of that. So finally, I don't mean to sound overly critical of agencies or their staff here. As I just mentioned, we need to all be doing our best to interface in a more polite and effective manner with agency staff. But if we're talking about truly overhauling the way agencies interact with the public, I think it's important to recognize that these agencies too often are dismissive of comments that they receive, too dismissive of feedback that they get from the public. I think too often agencies view public participation requirements in the law as if the purpose were merely to give the average Marylander a chance, an opportunity to speak their mind. But that's not actually, in fact, the way that these laws were designed. They were designed with an understanding that most, quote, experts in the real world are not employed by state government, but elsewhere in the private sector, in academia, or by quote average people. So if the point of these laws is to ensure that the best policy choices are being made, the agencies need to make a meaningful public participation opportunity available to really seek the best possible input. I think too often, certainly among the more cynical of us, it seems like their policy choices are guided by their political agendas and not by what is actually going to lead to the best optimal outcome. Next slide, please. So proactive consultation, I think, is sort of, it's like public participation 2.0. It's not merely putting out a call for feedback and allowing comments at, during a comment period or at a hearing. It's proactively seeking out input from specific people. We know that many agency decisions affect a certain area, a certain neighborhood, or a forest or a wetland or whatever, or a type of entity, say an industrial facility. And other decisions are statewide, but they might have a disproportionate impact on certain communities. Traditional participation sort of pretends that everyone is on an even playing field, but we all here know that's quite obviously not true. Not only do certain policies have disproportionate impacts, but also some vulnerable communities, or I suppose most vulnerable communities, are by definition less able to participate in these very processes that would enable them to protect themselves. It's not enough for agencies, in my opinion, to sit back and sort of cast a line and see what comes up. They have the information they need to determine who or what will be most impacted by a proposed action. And at least in certain instances, they ought to be proactively reaching out to those who have the most at stake. That would be very much not the status quo in Maryland, or frankly, anywhere, I imagine. But it is not far-fetched to envision that future where the agencies are really, truly trying to establish a meaningful opportunity for the public, the most affected in the public, to shape their policies. So there are many ways to do this. Some are relatively cheap and easy, like requiring public notice signs to be posted on site and readable in multiple languages and in large enough letters. It could also be somewhat easy things like creating an interested party sign-up list online so that folks who have a, concerned citizens can get information at the earliest possible opportunity about actions that might be affecting their community. Some options might also be more expensive, but certainly more robust, such as creating a community liaison officer within an agency or requiring those that are seeking a permit or authorization from an agency to designate someone within their entity, within their organization, to work in the affected community and seek out local representatives or leaders to get their input. Another similar, more expensive but useful option would be to conduct a cumulative impact assessment to determine whether the action being sought or proposed would further burden an already burdened community, and if so, force mitigation of that impact or deny the permit or authorization altogether. Some of you may be familiar with a law that just passed in New Jersey on cumulative impact. It's an incredible bill, law now. I think it was just signed recently, and I'd encourage you all to take a look at it. Next slide, please. All right, finally, I won't spend much time here. Again, I don't anticipate there's too many lawyers here, but you know, NEPA has a role for lawyers, not just the agency or the public. Given, you know, what, you know, some of the language that Russ referred to earlier, Russ is very much, I think, correct in calling NEPA a dead letter. I think that's pretty obvious. But as Russ also knows, the law doesn't care how old a statute is or how often it's been used. A dusty old law is still good law. That's part of the fun and games that lawyers play. And if we needed a reminder that a dusty old law can still be potent and powerful, well, we don't have to look very far. The Trump administration recently used the old Congressional Review Act in 2017 to invalidate a number of important and powerful regulatory safeguards put in place by the Obama administration. The Congressional Review Act went from a dusty old law to a very powerful and prominent law, just like that. So yeah, NEPA may be old and dusty, but it's not arcane. It's not powerless, as we're discussing here today. There are a number of ways to give effect to NEPA, and I would say one of them should be and could be lawyers citing to the law and its lofty language in crafting their claims, even if it doesn't necessarily provide a cause of action itself. I know that's in Russ's paper, and it's something that all the lawyers here today should be thinking about. Next slide. Right, so NEPA's limitations. I don't want to be pessimistic, so I'm going to keep this one relatively short, but I do want to be clear that this is not a panacea. It's not a constitutional amendment, and not even close. We touched on one of the limitations already, which is that NEPA is not NEPA. For those who know NEPA well and are coming to this webinar expecting, to find a Maryland NEPA sitting on the shelf unused, please don't. As I mentioned, the EER tool is not an EIS, and even if it were, there's little appetite politically for duplicating the EIS process, even in a quote unquote blue, I'd say purple blue state like Maryland. Moreover, NEPA is not self-implementing. I think this is incredibly important to understand. Part of the reason we're having this webinar today is that there is a role for each and every one of us to play if we want to give effect to NEPA. The reason it became a dead letter is because the agencies ignored it, and so did we, so did the public. If we want NEPA to have any sort of effect, it's going to require effort. It's going to require calling upon the agencies to adopt regulations to give effect to NEPA. That's how it's given effect. The EER arguably should be produced regardless of what any of us say. The agencies are kind of on the hook to be doing that, to be producing EERs already. There's that aspect. The rest of it requires agencies to adopt what the law calls methods and procedures, but in reality, under Maryland's APA, are regulations. So we need to, if we want to give effect to NEPA, push the agencies into creating these regulations. And then finally, I'll just end by saying, as far as limitations are concerned, MIPA does not provide any new rights. I mean, arguably, it only creates processes and a few new obligations for the agencies. So even though it teases us with this inalienable right language, it more than likely provides us no actual new rights. So that again is why the constitutional amendment is needed and why this is not a replacement for it. Next slide, please. Okay, so this is sort of just a summary slide. I think what I want to leave you with is, as I mentioned, the need to push the agencies to adopt regulations, right? Because if we're going to unlock any of the potential benefits that I spent time talking about, it has to be through the process of adopting regulations. And it is going to require some degree of creativity to fit an old statute with a new world, with the modern world. I laid out a bunch of potential benefits that MIPA could have, but all of those would need to be placed within regulations to actually guide the way the agencies operate. Without those regulations, none of this is really possible. And I would say that the place to start would be the environmental agencies, right? And as Russ mentioned, we have the Department of Labor Licensing and Regulation adopting MIPA regulations. That's not going to do a whole lot. However, ironically, the three, quote, environmental agencies in Maryland, most notably the Department of the Environment, but also the Department of Natural Resources and the Department of Agriculture, they don't have regulations to adopt MIPA, to implement MIPA. So that would be the place to start. And then beyond that, Department of Transportation and Planning have regulations, which is good because those are agencies that have some environmental impact. Then you would have to sort of go out from there looking at some of the other agencies that have more of an impact on the environment. I don't think too many are actually coming to me, maybe the Department of Health, I think. But that's where you all come in. You all have the knowledge and creativity to think through which agencies ought to be adopting MIPA regulations and what they ought to look like. So I think I will leave it there, and we're both happy to answer any questions.
Thank you so much. A lot there. The goal of this webinar was to put in your hands, all of you who are on this webinar and those who will be listening to it afterwards, to put in your hands the knowledge of MIPA, the excitement of MIPA back in 1973, the disappointment and frustration of MIPA, and the continuing promise of MIPA. This is a tool that we all can use. Someone in the chat said we're going to need legislative leadership. If we want to amend the act, we will need legislative leadership, and that is something that I'm hoping in the future we can talk about. Do we want to amend the act, and what would that mean? But short of that, and this is something that Russ and Evan have talked about and really fires me up, is that, and maybe Evan, I'll ask you to talk about this in a minute. There is a tool called a petition for rulemaking, and it is how we can get the agencies themselves to look again at MIPA. And by the way, it might not even be again, it might be for the first time, because so many people don't even know that MIPA exists. Have them look again at MIPA and say to them, you have a mandate established in 1973 to create these methods and procedures that will enhance the public's ability and your ability to protect the environment. And what we want to do, as Evan was saying, is work with you as partners to help you create those rules and regulations, which would increase transparency, increase communications with potentially affected communities, increase public engagement, increase the findings of any of the actions that you're going to be taking, right? We want to work with you on creating those methods and procedures. So I just want to say this is about renewal, right? This is about resurrection. This is about, as Russ was saying, revivification. We have got a sleeping giant here, and we can use it. And the more of us who use MIPA, the more of us use the petition for rulemaking, which I'll stop talking in a minute and let Evan talk about in a second. The more of us who approach our agencies and say, tell us, what have you done to implement MIPA? Just even asking that question as you sit there and you talk with these agencies, what have you done to implement MIPA? They might look with you with a blank stare and they might tell you something, but we can, if we go at them as a wave and say MIPA needs to be reinvigorated, what have you done with MIPA and how can we reinvigorate it? I think we can get a lot of traction. And as Evan said also, and as Russ said, this is not going to be a silver bullet. It's not going to take the place of the amendment. It's not going to be the be all and end all, but it will move us forward in a coherent and I think in a broadside way, and each of us has a role in that. So Evan, can you talk a minute about petition for rulemaking?
Sure. So the Maryland's APA, the Administrative Procedure Act, like the federal APA, provides a right to the public to submit a petition to an agency to begin the rulemaking process. So, you know, obviously the agencies also are provided under the APA the right to deny that petition. And that's something that each of us need to understand as you're walking into that process. It's a collaborative process. If you attack the agency, blindside them with a regulation that is probably overly bold and ambitious, you're going to walk away empty-handed. So I think it would behoove all of us who are engaging in this process to reach out to the agency early and think about what's reasonably achievable. Laws, legislative campaigns, you know, are also implemented in the same way, right? You think about what's sort of at the outer edge of achievable. You push for it and then maybe you make a compromise. Same thing with the regulations. You can't walk in and say, I want this, that, and the other thing. You have to say, here's what we are thinking. How can we make this happen? I do think it's important in the case of MIPA to understand that we do have a little bit more leverage than under your average petition for rulemaking, in that MIPA requires the agencies to adopt these regulations. So you can cite to that right off the bat. This is not a situation where we're politely asking you to do something that we want you to do. We're asking you to do something the law requires you to do. Now, within the confines of that obligation, we all need to then be understanding that the law doesn't provide a whole lot of detail on what those regulations need to contain. So that's where you have to have that sort of give and take with the agency and think about what's reasonably achievable.
Great. And you should know that the Maryland Campaign for Environmental Human Rights has begun the conversation with MDE, telling them that we are going to be approaching them with a petition for rulemaking. We wanted to give them a heads up on what we were doing. We want to be a partner with them. They are all about communication and transparency in the conversation that we had with them. We're going to hold their feet to the fire about that. And Evan was gracious and created a petition for rulemaking with examples of the rules and regulations we would like. It's a 14-page document. I'd love to share it with any of you who are interested in working with us and MDE. We also want to go to DNR. We also want to go to the Department of Ag. That is we, I don't mean Maryland Campaign, we can't do this all, but for those of you who are working with farms on the Eastern Shore, and those of you who are working, yes, with PSC, and those of you who are doing that, consider approaching those agencies, again, with the question, what have you done with MIPA? How have you implemented MIPA? And potentially talk about submitting to them a petition for rulemaking. I want to go to Russ for a minute. And yeah, so who have you been talking with at MDE? We've been talking with Suzanne Dorsey, the Deputy Secretary. But who is that? Jody? Jody, I'd love to talk with you about that. Morgan, absolutely. I will capture all this chat and get back to you. Russ, your presentation today, you sort of got the hard part to say, look at how wonderful MIPA is and look at how disappointing it is. And then you hand it over though, but we can reinvigorate it to Evan. But let me turn back to you and give you a moment to talk about how in your paper and in your subsequent thinking, how you can inspire us and encourage us to reinvigorate MIPA. What is your visioning of reinvigorating MIPA?
Well, there are a couple of things. One is an instruction to lawyers. The language which I read to you about how all agencies are required to interpret their regulatory obligations in accordance with the policies of MIPA. I think that could be another argument. It would not, as Evan says, give anybody a separate cause of action. But if you're suing to challenge a permit, if you're petitioning to invalidate a regulation, or you're asking agencies to modify a proposed regulation, citing that language would, I think, be useful. Say, look, you know, you have a statutory mandate to interpret your statutory authority in accordance with these strong environmental policies. This regulation, this permit doesn't do that. That's one way, and that's really something for lawyers. That is a tool that lawyers could be using. The second thing I would love to see happen is for us to go to state agencies, in particular the ones that have been mentioned, environment, natural resources, agriculture, and maybe public service commission, and say to them, you don't have the environmental effects reports aspect of MIPA isn't worth very much because you don't go to the legislature to ask for legislative action or for an appropriation very often. If you do, you should be doing that. You should definitely be doing that. But you shouldn't, you should also, we would like to see you, as part of the methods and procedures you're required to adopt, we would like to see you create an obligation that every time you make a decision that has a potential impact on the environment or on human health, because the language goes beyond just the environment, narrowly conceived, you should make specific findings about the effect of your action, your proposed action on the environment. It doesn't have to be as extensive as an environmental effects report might be. As those of you who've worked with NEPA know, environmental impact statements sometimes take years and cost millions of dollars to prepare. I don't think in this political environment we're going to get anywhere asking for that. But asking an agency to think about the environmental impacts and to make specific statements about the environmental impacts of their actions, I think is not too much. And all of us who know about how human psychology works, if you require people to think about something and to think about it explicitly enough so that you can write down something about what you are doing and what its impacts are, you get changes in behavior. I'm a securities lawyer by background, and I know that's what the SEC has done. It uses disclosure in numerous ways to force corporations, big public companies, to make statements about things that it's doing, not because they are particularly interesting for an investor, or at least not the investor who's only interested in making money, but because making people think about what they're doing and write down what they have decided about what they are doing and what its impacts are does change people's psychology. And I think that could be a very powerful tool here.
So I want to echo that. The more the Pennsylvania Environmental Rights Amendment was dormant for 40 years. The courts had said it means something, and therefore it sort of denuded it. Nobody paid any attention to it. For 40 years, it was dormant. Now it has exploded into an amendment that has meaning, that is enforceable. In other words, the dormancy, as we've been saying here before, Russ and Evan have been saying, dormancy of MIPA should not let us believe that it cannot be reinvigorated in a very powerful way. And it hasn't been interpreted narrowly. If we all come at these agencies with the questions when we sit down with them, how have you interpreted MIPA? How have you implemented MIPA? Show them language that expands the past interpretation of MIPA. That in and of itself can be a beginning. But I want to ask you both two questions that have been coming up here. One, by Jamie DeMarco. Is there discussion of bringing a lawsuit against the state for failing to implement MIPA in all the agencies? Is that a possibility? And what do you know about that? And two, several people have asked, does MIPA apply to the sub-state level? Does it apply to the county and city level? So who wants to take those?
I can take the second one first. No, it does not apply to the local level. It defines state agencies. It does define state agencies broadly, which may be of interest to some people. I'll just read it. State agencies include the executive and administrative departments, offices, boards, commissions, and other units of the state government, and any such bodies created by the state. So that's the answer to that. No to local government, but yes, widely and broadly to state government. Russ, do you want to take the lawsuit one?
Yeah, as to the lawsuit, the statute speaks to the agencies, not to the state itself. So I think a suit against the state doesn't have much chance. As Evan said, I think it would be more effective to approach the agencies, in particular the more important ones, individually with a petition for rulemaking. In other words, ask them, before you sue them, ask them to do what they're supposed to do, give them a chance. And then I can't say I am particularly optimistic about the chances of a lawsuit succeeding. Unfortunately, the Maryland Administrative Procedure Act, unlike the Federal Act, allows agencies to respond to a petition for rulemaking by saying, no, thank you. We don't want to do that. Go away. In the federal law, if you file a petition for rulemaking, you are entitled to a substantive response. The agency can either conduct the petition, conduct a rulemaking along the lines you've said, or give you a reason why not. And if the reason is inadequate, you can sue the agency and say, no, you really must. You must engage in a rulemaking proceeding. Unfortunately, Maryland law doesn't work that way. It is, I won't say it's impossible, but I wouldn't say that a lawsuit trying to force an agency to adopt rules and regulations is particularly likely to succeed.
Yeah, just to add to that, I would say you would have to think creatively about that lawsuit, that's for sure. I will say the one benefit of the Maryland APA over the federal APA with respect to rulemaking petitions is that at least at the state level, they are required to act quickly. They have 60 days to respond, whereas the federal level, they often drag it out for months and months and years, and sometimes just never do anything at all, and you have to sue them to get them to do something. So yes, you don't have the right to sue specifically under the APA, but at least it does give you a quick, easy response.
Well, what we are talking about is partly legal and it's largely political. Agencies can be forced by political pressure to respond to reasonable requests from the public, much more effectively sometimes than they can by lawsuits.
It's a wonderful way to end. I want to echo that before I thank you. I know Ethan says, would it be helpful, for example, if members of the public, for example, students, reached out to these three departments and asked them, have they used MIPA? So I want to say, the Baltimore City transit system changed its ways of determining which bus lines it was going to cut because of public pressure. Ben Grumbles, the Secretary of MDE, responded to, I think Kathy's on the phone, to Assateague Coastal Trust and others who wrote a public letter saying how the Commission on Sustainability and Environmental Justice has not been living up to its mandate, and the MDE is going to be responding to that. We can, I think, just as Russ was saying, using our political pressure, continually asking these agencies, how are you implementing MIPA? How are you implementing MIPA? Let them know that we're continually looking at them for implementing MIPA. We can help move the needle it is not the be all and end all, but it will be if it's a wave coming at them, then I do think that that sort of political pressure can help move them, probably even more than lawsuits. But let me say, because we're at the end of the hour and I know people have to run, Russ, thank you so much for writing that paper. Thank you so much for inspiring us to move forward. We will send out the paper again. I encourage you all to read it, because never mind the frustrations that we've had and the disappointments, MIPA can be reinvigorated, and it is an enormously useful tool for all of us to use and to reinvigorate. Evan, thank you for bringing this to our attention. It is just wonderful having you, and the knowledge that you have because of your intimate experience in Annapolis is invaluable. And I think I saw in the chat some people might be reaching out to you to talk about how they should move forward with our conversations to the agencies. Thank you all for participating. We will be sending slides out. We will be sending a link to this recording. We will be sending out Russ's paper. And I ask you all, if you are interested in pursuing petitions for rulemaking and approaching agencies on how they are implementing MIPA, let me know, because I would love to have the Maryland Campaign for Environmental Human Rights at least be a round table for talking about this, so we can each keep each other apprised of how we move forward and see how we can strengthen each other in the ways we move forward with the various agencies we approach. So with that, I thank you all, and let's keep in touch. Russ, Evan, thank you. Everybody, thank you. Claire, thank you. Take
Thanks,
care.
Dana. Thanks, Claire.
Bye.
Thank you,
Thanks,
guys.
Dana. Bye.
Thanks. Take care.